and it can be done very efficiently. So the efficiency of these gifts has to focus on, are they things that will create substantial income tax in the future, which will be taxed at a lower rate to the recipient, right? And are they also things that are going to appreciate, which ties in with your estate planning? Now, I realize that when you talk about gifting that there is this sense that you have a loss of control. And I know that's a huge issue because often you're gifting to children and other people that you may not have confidence in their ability to manage assets. As we talked at the beginning of this show, that control management concern. So there are some ways, though, you can address that. And they're a little more sophisticated. So let me do a little more discussion here, and then I'll try to come back to that today. So you have the lifetime credit. You have the $12,000 per donee per year per spouse lifetime exemption. And the tax rates, just so you know what's involved here, you're talking about a tax rate of gift or estate of around 45%. And because these are compressed, what are called compressed tax brackets, that means that they rise very rapidly, these marginal rates. So very quickly you go from zero taxation up to this 45% ceiling. And it applies to both gift and estate taxes. Now many of you are aware that in the year 2010, the way the Sunset Law was written in 2001 when this legislation was passed that created more favorable rates for people in estate planning, that's supposed to disappear after 2010. So in 2010, as it sits now, there will be no taxation for anyone who dies at that point relating to gift and estate taxes. So during the year 2010, there's no taxation as it's presently written on the gift and estate tax. And wait, let me back up. I think it's just the estate tax. I think they separate the gift. So the gift would still be in effect in 2010, but not the estate tax. However, let me qualify that. To the extent that you survived 2010, there's good news and bad news. Well, it's good news that you survived, but it's bad news that now you fall back to rates that were in effect prior to 2001 and are disadvantageous to you, worse than what's been in effect for the last 10 years. So there is some uncertainty what lies ahead then. We don't know. When I talk to other lawyers in this field and we bounce these ideas around, none of us has a clear consensus for what's going to happen. Most of us believe that Congress will act and probably preserve something similar to what's been in effect in the most recent years, meaning 2008 through 2009 is what we think will end up being preserved. I don't think that Congress is going to allow us to go along without any estate tax at all. It's a very popular tax. It's funny, estate taxes, though, as a practical matter, only generate, I think, less than 1% of the total revenues of the federal government. So it's not a significant thing monetarily, but I think it has huge value from the perspective of the taxpayer. I think that it's more of a psychological or a principal factor than it is a monetary one. There's some sense that it's just that you break up these fortunes after someone dies and that somehow it be redistributed to others so that they can be encouraged to start and rebuild new fortunes. It's the notion that you can't allow consolidation of wealth, and that's been a popular theme in America. Even our income tax code is predicated to a great extent on redistributing wealth. But certainly the notion of estate taxes is. So we don't know exactly what lies ahead there, but I do think that given the political popularity of estate taxes that they'll continue to be there. Let me move forward and I'll talk a little bit about the estate tax. You have a $2 million lifetime credit. Now I mentioned that you and your wife both have this credit. That requires a little explanation. We have in effect, what's been in effect for some time, for a number of decades here in our tax system, that is very favorable to spouses, to married couples. So for a long time, though, there was different treatment among states that are common law states versus those that are community property states as to assets that were held jointly when one of the spouses die. Now, many of you who live in common law states probably know that there, if one spouse dies, then it's assumed that half of the marital estate belonged to that person and would be included in their estate. With respect to the common law states, it was not as clear how that would be allocated. It was driven to a large extent by how property is owned, whether it's titled in one party's name or the other. And it wasn't driven by this 50% notion that community property was. But at the end of the day, the federal government wanted equal federal estate tax treatment for people who are married, whether or not it's community property or common law, and that's where we are today. It's actually quite favorable. There's what's called this unlimited marital deduction. That means that a person that has $1 billion and he's married, when he dies, there will be no estate tax owed if all that goes to his spouse, because it's subject to the marital deduction rules, which means that the death of the first spouse, the surviving spouse, if they own all those assets, will not be taxed at that time. They get to postpone the taxation of those until their death. So that means that anybody can count on avoiding taxes till the death of their second spouse. Now it sounds real attractive, but if you think about it, it very quickly raises questions and concerns. But I want you to grasp that fundamental idea that you can easily avoid taxes till the death of the second of you. Now, if you make assumptions that the second spouse will die many years later, if we assume that, then that gains a benefit to that approach. If we assume that second spouse has the capability of managing effectively those assets, there won't be the vulnerability to fraud and manipulation by others. If we make assumptions about second marriages, etc., is that something that is acceptable in terms of your ideal estate plan? There are things that if they worked out okay, that would be a wonderful approach to avoiding taxation, and that could be the central feature of some people's planning. As a matter of fact, some people on the most basic level will simply do estate planning that assures that all their assets go to their spouse and that they avoid taxation at that time, and they don't worry about the implications at the death of the second spouse. But that's really very short-sighted, and it often can result in a lot more taxation than if you had simply done some planning in advance. And we know that those assumptions that I just gave you in that example often don't happen. Sometimes you'll have spouses that die simultaneously in a car wreck or whatever. Other times, and this is quite common, the second spouse will die soon after the first. As a matter of fact, statistics show that when you have marriages in which spouses have been married in excess of 30 years, that most spouses, I don't know the exact number, the exact percentage, but it's a surprisingly high percentage of second spouses will die within 4 years of the death of the first spouse in those scenarios. In any case, it may turn out that what seems at a glance like a wonderful thing in terms of your planning really is not of much value to you, or at least not much confidence can you derive from this tax benefit. So what most clients do is that they decide that the marital deduction trust or marital deduction that's available to them is something that they should use, but they should use it in conjunction with other assets and tools and techniques that are available to them. Now that's kind of what I've given you here is a sort of quick overview of the estate and gift taxes and the income taxes. And I could say a whole lot more, but I wanted to keep this to a level that it makes sense to you, and then we can come back and talk about these things more in the future. Okay, now let's go back to the subject of lifetime gifting, because really lifetime gifting is about estate planning. And if that's done correctly, then you're going to achieve a goal of minimizing or avoiding entirely any estate tax at your death and the death of your surviving spouse. And I want to come back to some ideas that I've spoken about briefly and kind of interweave them into this discussion that we've had today. We've talked about irrevocable trust. I want you to accept that as a wonderful tool for doing a gift. It allows you to address that concern we raised a while ago. Whenever you make a gift to somebody, you know there's got to be a surrender of dominion and control. It has to be a completed gift if you're going to get these tax advantages. And how do you do that if it's somebody that you don't feel is at a point that they can be entrusted with unbridled control over those assets? And the way you do that is with an irrevocable trust. Now, creating an irrevocable trust allows you to create rules as to how that's to be distributed without your continuing to participate on a regular basis. So there's not the problem, if it's done correctly, with your violating this notion of a complete transfer. It's a complete transfer, but it's under terms that you've defined. You've specified who the trustee is going to be of this trust. You've specified the terms under which it will be distributed. So that it's a wonderful vehicle for you to transfer assets and at the same time maintain control, but it's control that you